Hello, my name's Emma Fuller, Edward Hanson Lewis. Thank you for joining me today. I hope the webinar is going to be of interest and informative for you today. I'm a solicitor and director of Edward Hanson Lewis, and I'm a member of, affiliate member of STEP, which is the Society of Trust and Estate Practitioners, and also affiliate member of the Solicitor for the Elderly. I today will be talking about lasting powers of attorney and then briefly about wills and probate. So, ageing population. Today, people are living longer and healthier lives due to diet and medical advances, and this is keeping obviously people alive a lot longer, but can have some impact on their mental health and on their physical health. So as we become older, we may become frail in body and in mind, and may not want to be able to keep dealing with our affairs. Now, with obviously the increasing life expectancy comes diseases such as dementia and common cause of dementia, Alzheimer's, and they can stop a person from making decisions about their health and welfare. Now, some statistics. In the UK, there is 40,000 people under the age of 65 currently that suffer with dementia. And you may have heard on the news yesterday that 44 million worldwide suffer with dementia, and they expect that in 2050 there'll be 135 million people suffering with dementia. Currently in the UK, women appear to be suffering more than men, and 500,000 women suffer with dementia, and this is the leading cause of death in the UK of women. Also, we're living obviously a lot longer, and in 2012 there were about 13,000 people who were over the age of 100 years, and 660 were actually 105 years old. So it may not seem a lot of people in the UK, but actually that's extremely high. And there's about 500,000 people over the age of 90 currently alive. And one statistic says that there is a child or a baby now living who will live to 150. So it's just, we're becoming sort of older and suffering with various debilitating illnesses. So if we become frail and mentally incapable, we need to think about somebody else taking over our affairs. Now, I'm going to be talking sort of a couple of legal jargons, I suppose. One is the donor. The donor is the person who makes a power of attorney. The attorney is someone who is the person the donor appoints to act on somebody's behalf. And I'll be talking a bit about mental capacity. And a mental capacity is the ability to make decisions and go through the decision-making process. And so, if we talk about types of powers of attorney that are in existence currently, we've got three principal types of powers of attorney. One is the ordinary or general power of attorney, and this is a legal document but doesn't get registered at the court at all, and it allows an attorney to act on behalf of the donor. These tend to be temporary or for a specific purpose. So if I went to France, for example, just for a holiday, and I was going to be there for a month, but I was in the process of selling my property in England, I could appoint somebody else under a general power of attorney to sell that property on my behalf. So it's for that specific purpose of selling that property. Now, to be able to enter into a general power of attorney, you have to have the mental capacity to enter into the document for the existence of that document. So I enter into the document as the donor, I give the attorney the right to sell my property, and for that whole transaction I have to have mental capacity. If I, as the donor, lose mental capacity by maybe having a stroke or having a car accident, for example, that could affect my mental capacity, then the attorney could not continue to sell that property. So it's very limited, and that's why it's for a specific purpose and temporary. It doesn't continue if I lose mental capacity. The ordinary power of attorney can actually cease as well if I revoke it. So I can, in a general power of attorney, say I would like my attorney to deal with my finances for me, and then I decide, well, I don't actually want that attorney continue to do the work for me, so I can revoke it by doing another deed, and that will then cease the general power of attorney. And if the attorney loses mental capacity, then the general power of attorney will also cease. So what can be in place if I lose mental capacity? Well, you can have an enduring power and a lasting power. Now, the enduring power of attorney can only is still valid, but they can't be made now. So they have to be signed by the donor and the attorney prior to the 1st of October 2007 for it to be valid. You can't make them anymore, but the ones that have been made can still be used, and they are obviously still very important. You may need to actually have them reviewed. I have seen people who have asked me to have a look at their enduring powers of attorney and found that they have signed the document, but the attorney hasn't. And so, it isn't valid. Also, if the attorney under the enduring power of attorney has died and there was no other replacement attorney, then the enduring power of attorney will cease, and so you may need to make a lasting power of attorney. So with these documents, it's worth having them reviewed to make sure, one, that they are valid, and two, that they will do what you want them to do. Again, you can revoke the enduring power of attorney, but this power of attorney only deals with your finances. So it is a document that enables an attorney to go to the bank, sort out your bank accounts, investments, sell your property. Now, you can restrict in that document that it only takes effect again if you lost mental capacity, but most people would probably have had it wide that it takes effect if you want the person to take over your affairs, if you became physically frail. You also, with the enduring power of attorney, it's about a 4-page document. As soon as everybody signed it, so long as there was no restriction, it could actually be used by the attorney as soon as you wanted it to. It didn't at that point have to be registered with the court. Now, if you became mentally incapable, the donor became mentally incapable, then you would have to register it with the court. So there would be a period where, for example, I'm in my 90s and I want to say to my daughter, would you please take over my affairs for me because I don't want to deal with them anymore. My daughter takes over. I then have a serious stroke that affects my mental capacity. My daughter would then have to stop using the power of attorney for a period of time for it to be registered with the court. And once it's registered, again, it can start being used. So that period of registration probably takes about sort of 8 to 10 weeks to get everybody notified and for the court to actually validate it and say that it's okay to use again. So then we have the lasting powers of attorney, and I'll go into detail about lasting powers of attorney in a moment, but there are two types. There's the health and welfare and the property and affairs. So the property and affair lasting power of attorney is the new type of enduring power of attorney. The health and welfare is a completely new deed. And so if you had an enduring power of attorney, you may want to have a lasting power of attorney, health and welfare as well. You don't need to have the financial one, but you may need to have the health and welfare. So I'd go on to first what would happen if I didn't have a power of attorney, lasting power of attorney. Now, I fit and well at the moment, but I have a car accident and it makes me incapable of dealing with. I have a brain tumour or something that affects my decision-making process, and I don't have a power of attorney set up, either an enduring or a lasting power. So nobody would be able to access my bank accounts for me. They'd be frozen. They wouldn't be able to sell my property if I had to go into a home. And so there would be a period of time when no one can actually assist me and look after my affairs for me. Also, there would be nobody who could make a decision about my health and welfare. So an application would have to be made through the Court of Protection, and the court is the Royal Courts of Justice in London, and to have a deputy appointed to take over my affairs for me. Now, the deputy can be a family member, they could be a friend, but you have no control, because obviously it's the person, you haven't got the capacity to appoint anybody, so it's that person who comes forward who takes over your affairs for you. And they have to make an application. Initially, a doctor or a consultant would have to make a decision that you couldn't make decisions on your own behalf, and complete a form to say that you were unable to deal with your affairs. And then an application has to be made to the court about all your finances and about your health and welfare if you wanted to make the two applications together. And that application goes to the courts of justice. A judge would have a look at the paperwork, and it's unlikely that there would have to be a hearing, but it's still a very costly process. You'd be looking at court fees of £400 per application, and this solicitor who makes the application can charge, the court set a minimum that we were able to charge at £850 plus VAT, but in fact the cost could be well over that. And then the court sort of take control. There are steps that have to be taken through the Court of Protection, and eventually the judge would say, yes, we're going to make the order, and you would then have to pay an insurance, and that's paid on a yearly basis. And for an estate probably of about £150,000, you'll be paying an initial insurance of £300 per year. And also the court can have supervise the deputy and say, right, every year you have to provide us with accounts, and the court can charge for the supervision fees. So you could be looking at fees in the region of sort of £2,000 if you had to make an application just for one of the applications, if you just wanted to deal with the finances. If you wanted to deal with health and welfare as well, it's double the amount. The deputy can be really a friend or family member, but you'd probably be wise to appoint two people just in case something happened to the first person. So you could have the husband and wife and maybe a child who make the application jointly. So to avoid having to go through the court of protection, you want to really get the lasting powers of attorney in place whilst you've got capacity to do so. There are two types, as I've said. There's the property and affairs and the health and welfare. And the property and affairs allows the attorney to manage the finances and basically everything that you need them to do to pay your bills, to invest your money, to open, close accounts, to sell shares. So anything to do with your finances, you can limit it and say that they can only do certain things, but you probably wouldn't want to do that because you'd probably want the attorneys to do everything that they can on your behalf, collecting in your pension, applying for benefits for you, anything to do with your finances. Now, the health and welfare covers what you eat, what you wear, who you see, where you live, and medical treatment, your doctors, your dentist. And there is a section that you decide whether your attorneys would be able to make decisions about life-sustaining treatment. So you could opt in and say, I do want my attorneys to make decisions about my life-sustaining treatment, or I don't. And life-sustaining treatment isn't just resuscitation, it can be blood transfusions and administering antibiotics. So when you appoint an attorney, you really need to be discussing, do you want them to make that decision, and do the attorneys want to be able to make that decision for you? Because some family members may say, well, I don't want to do that. Now, they go hand in hand, property and affairs. Some people, if they had to make a choice, well, which one would I go for? They would probably go in preference for the property and affairs, but they do go hand in hand because you'd want the property and affairs to be dealt with, but you also want your, people to be able to make decisions about your care and not necessarily leave it just to the social services or doctors, etc., health professionals to make those decisions. You'd want to be active in those decisions as well. The property and affairs power of attorney can take effect as soon as it's registered with the court. Or it's actually the Office of Public Guardian, which is in Birmingham. So you actually set it up, it's registered with the Office of Public Guardian, and at that point, as long as you don't restrict it in any way, it can be used by the attorneys as soon as you want them to use it. The health and welfare power of attorney can't. It can only take effect when you have lost mental capacity. So you suffer with Alzheimer's to the point where you no longer can make decisions on your behalf, and at that point the attorney can take over. So once it's set up and it's registered with the court, it may never ever be used because hopefully you may not need it. But if it's, I always said, a client said to me once, it's like an insurance. I've got it in place in case I need it, and I may never need it, and hopefully they wouldn't, but it makes it so much easier for your family if you actually have one in place. So, excuse me, the procedure. The donor obviously has to have mental capacity at the time of making the lasting power of attorney. You can appoint a minimum of one attorney, but you can have as many as you would like, and you can appoint replacement attorneys. So some people would initially appoint their husband or the wife to be an attorney for them, and if their husband or wife dies, they could then have replacement attorneys appointing their children to act on their behalf. Some people like to have a number of attorneys working together, so husband with children, and then maybe a replacement attorney. So you can set it up how you want to set it up. You wouldn't really want to just have one attorney appointed, because you do that and that attorney dies. You've obviously got no replacement set up, and the last in power will then cease. So you're going to all this trouble, it's worth having it quite wide to make sure that it will continue. It will continue, obviously, only if the attorney also has got capacity, because if attorney loses capacity, mental capacity, they can't act for you. So again, you need to make provision for that. And if you appoint a husband or a wife as an attorney, but then you divorce, then at that point, the appointment of that attorney will cease as well. So you need to be careful as to who you appoint and how you appoint your attorneys. You can appoint attorneys jointly or joint and several. Now, if it's joint, it means that they have to work together, they have to sign everything and agree to everything together. The problem that could arise with that is if one dies, then again that appointment ceases because you can't act jointly. So again, you may need to think, well, do I have it appointment joint and several? So if one attorney dies, the other attorney would be able to continue to act. I mean, you can set out in the document that some decisions are made jointly and others are made joint and several. But again, you've just got to be careful if you have a joint appointment that you've got replacement attorneys set up, because if not, it will cease. And I think really it's how you feel comfortable. People do make appointments jointly if they feel that they need that protection, that they need two people to be able to agree to decisions. Once you've decided who your attorneys are, you then, obviously they need to agree to it, and it's quite a big responsibility for an attorney to take on this role. So you would sign the document, the attorneys would sign the document, but only after somebody has confirmed that you've got the capacity to enter into it. And I'll go into that person and his responsibilities in a moment. You've also in that document got to decide who you would notify about the registration of this document. And this is a form of protection. So it's trying to prevent sort of abuses of people and undue influence. And so we notify people to say, we are making an application, these are the attorneys, do you have any objection? And hopefully those people won't object, but it's there to protect you when you actually go ahead and register the document. And in the last in power of attorney, you could actually say in the property and affairs one, it can't be used until I've lost mental capacity. But again, and that could be that you need confirmation but from the GP or the consultant that you have lost mental capacity. But if you restrict it, then again, if you became frail in the future, you may not. You may want somebody to take over your affairs and they're not able to. Unless you then go into making an ordinary power of attorney. So you may want to just keep it wide. So once it's registered, that can be used. And you can put preferences and details now in the document that will set out what you want people to consider. So say, for example, in the health and welfare power of attorney, you could say, if I had to go into care, I want to go into a care home in the local Leicester area or London or with my family. So you actually make a decision and you tell people what you want them to do. And they could just be preferences, so it's the attorney's guidance as to what you want, or they can be conditions, they are set in stone, that's what you require. And again, you have to be careful as to how that's drawn up. So you don't really want to restrict it if unless you have to. So the process, we draft the last in power of attorney according to what the donor wants. The power of attorney signed by the donor, somebody acts as a certificate provider confirming you've got capacity, and that can be a doctor or a solicitor. It can actually be a person who has known you for 2 years, but you may not want to go down that route, and I'll explain that in a moment. But it could be a neighbour who's known you for 2 years who could act as the certificate provider. Now, the certificate provider has to sign very shortly after the donor has, then the attorney sign. It has to be done in strict order, and once the LPA is actually signed, you don't have to at that point get it registered, but that could cause problems for you. So you have to decide whether it's important to get the LPA in place, because at the moment the court takes, well, they vary, but between 8 weeks at best and probably 12 weeks at worst, the registration process. So you've got your LPA all in place, your health and welfare and your property and affairs, and you put it away but don't get it registered. There could be a problem because you then have a serious car accident. I go back to the car accident, but you have a serious car accident and somebody has to make decisions about your health and welfare very quickly. Well, if it's not registered with the Office of Public Guardian, you can't make those decisions. So it is advised that once you've got your LPA set up, you actually do go through the registration process. And that is giving notice to the people that you'd named in the document to say you are getting it registered. And then you register it, just put an application with the LPA to the court, and then the court will look at it and check that everything's correct, and then stamp it and say, yes, this is validated, this is correct, and then return it. And then it's in place and it can be used straight away if need be under the property and affairs, if you want it to be used, or under the health and welfare, if somebody loses mental capacity, it's there. So with the health and welfare, you'd probably advise once it's registered to give it to your GP so they've got it on record if need be in the future. And the property and affairs, you may want to register it with the banks. You don't have to straight away, but that's something that you could consider doing. So once it's registered, it's effective straight away if it's the property and affairs and you haven't restricted it, or with the health and welfare if you lose mental capacity in the future. And so obviously you're covered in case there's an issue. And I always say with powers of attorney, people do think about wills. People don't necessarily think about powers of attorney, but you need something in place to look after you whilst you're alive. And so people think, well, when you're 90, 80, 90, you ought to get these in place. I'm half that age and I've got the old law enduring power of attorney in place, ready in case something happens to me overnight. I know that my family can look after me if I need them to. So I think that it's across the board. We shouldn't be thinking, oh, well, you know, my parents need it. I think we should be thinking, I need it, my parents need it. And obviously you can make them as soon as you're 18. You can only appoint people who are over 18 to act as your attorney. And as the property and affairs attorney has to be somebody who has never been bankrupt. The health and welfare attorney could have been a bankrupt, but obviously the power of attorney, property and affairs, you need somebody who can manage their own money. If they can't look after their own money, they shouldn't really be looking after anybody else's. But at the time that you're probably thinking about doing your LPAs, you may also want to be thinking about your will. You know, if there is an issue about capacity, because you could have first stages Alzheimer's, and we do get quite a few referrals when somebody has first stages Alzheimer's. The GP is very good and will say you need to sort this out now. If you don't have a lasting power, you need to go and do so. And so we see clients, and at that point you need to have your will looked at. If you haven't made one, make one, and if you have one, just get it looked at, because you want to make sure that it is right, because you may not be able to change it in the future. Again, if you lose mental capacity, you can't change your will. If you haven't made a will and you've lost mental capacity, you can't make a will. You would, in that situation, have to apply for a statutory will through the Court of Protection, and the costs, again, you'd be looking at, rather than a £120 will, you could be looking at a £1,200 will. So you really need to get your will in place and looked at. And again, we do reviews for free, just to check that they're what you want to do. And then you've got you may also want to think about, they're called living wills, advanced directives, advanced statements. Now, an advanced statement is setting out, it's not legally binding, it's just a document that sets out your wishes about where you would like to live, who you're quite happy to see, what you would want to eat. And that is quite important to have with your health and welfare power of attorney, because you want people to know your views. What would you like? And you can set that out in an advanced statement. An advance directive decision is about refusing treatment if you have certain illnesses, and they are legally binding if they're set up correctly. And before you enter into one of those documents, because they're binding, you would really want to go through it with your GP and your family, so everybody knows what your views are if you suffer with an illness that would result, because the advance directive can actually be, I don't want treatment which could result in my death. And so it has to be very clear what you want to do. They're not very flexible, because you could set that up, an advance directive, in 1990, and then over the sort of 25 years there have been a lot of medical advances, and you wouldn't have known about them, and so they're very inflexible because you haven't taken that into account. So the health and welfare power of attorney actually enables that flexibility, because as advancements in medical treatment are found, then obviously the attorney could say, well, actually, we want to take this treatment because it's going to assist my parent or whoever. So you can have them hand in hand with the health and welfare, but they aren't so flexible, and really preferably you should have the health and welfare power of attorney. So just moving on to wills, when you make a will, or if you need a will reviewing, what do you need to consider? You need to consider who would be your executors and trustees, so who would deal with your estate on your death. Now, your attorney for an LPA could also be your executor. So whilst you're alive, your attorney makes decisions, but when you die, the attorney role stops and the appointment of the executors then takes over. The executors, if they are different, they may actually question what the attorney's done during the lifetime, and they may want accounts, and also the beneficiaries may question the attorney. So the attorney needs to have accounts and receipts for what they're doing in case that is questioned in the future. You can put in your will about your funeral arrangements. Again, this isn't binding, it's your wish. It'd be taken into account by your family if need be. Who do you want to inherit from your estate? Who are your beneficiaries? Executors can be the same people as your beneficiaries. So you could have your husband, wife, children, grandchildren. And then also, if you've got young children under the age of 18, do you want to appoint guardians in your will? So and you can have very simple wills, which I say are a will that says I give everything to my husband, everything to my wife, then to children, then to grandchildren. That's quite a simple will. We can go into very complicated wills, and I'll explain that in a moment. So we've got the will that you make. You need to make it tax efficient. Now, in the Finance Act 2008, it changed the way we could transfer an allowance, the nil rate band it was called, that we could transfer it between husband and wife. So if I die and I give everything to my husband and then he dies, and gives everything to children, then I have an allowance currently £325,000 before I pay inheritance tax. My husband also has that, and if I gave everything to my husband, it's spouse exempt. After his death, he can then, or the executors can claim £650,000 of before any tax is paid as a maximum, and that may obviously increase with the budget a couple of weeks ago. The wills prior to 9th of October 2007, you actually had to have very complicated wills to use up the allowance, and they may not be what you now require because they were complicated. They may not do what you want them to do now, although they were very tax efficient prior to 2007. So if you have a nil rate band will, a complicated will, you may want to just talk through with it to decide if that's the best way to keep the will set up. And it may be correct still, but you just need that looking over. We've got, do you want to then consider another complicated will, which is the property, they're called property protection trust wills, right of residence wills, life interest wills. They're very, very similar, and what they do is that they're quite important for second marriage. But if I give you an example, you can see why they could be quite important. So I'm married. I have two. This is just an example. I'm not, but I'm married. I have two children. My husband has two children from his first marriage. I have two children from my first marriage. I decide to give everything to my husband on my death. We have done wills that give each other everything, and then on death we give to all our four children equally. I die, I give everything to my husband. He then thinks, actually, I didn't like Emma's children at all, so I'm going to change my will and I'm going to leave everything to my two children. So my children get nothing, and they may not be able to make a claim against the estate at all, and so they've lost, what I've worked for maybe. So you can set a will up whereby the house, for example, is owned in shares, and I give my husband the right to live in my property for so long as I want, so long as he wants, but on his death it goes to my two children. And so he never owns my share of the property. He's got a right to live there as long as he wants up to his death. But on death, it's guaranteed that it will go to my two children. He can do what he likes with his half share, but he can't do anything with my half share. And so these are important, like I say, for second marriages. They can also be important for first marriages, because I give everything to my husband and he decides to remarry, fine. But he forgets to make a new will, and the will that he made was revoked. And so again, his new wife ends up with all my property and his property, and our children don't get anything. So they can be important for first marriages as well. And so you'd have to sever the tenancy on the property, and it just protects your children from in the inheritance. So like I said, if you remarry, a will is revoked, so you need to make a new one. If you divorce or separate, you may need to change your will, update it. And if you sell or obtain assets, you may need to update your will. So you may not. Sometimes wills are written in a way that are correct and last a long time, but it's worth actually looking at having them reviewed. And then just briefly, probate. So we've dealt with attorneys last in powers whilst you're alive, then the will whilst you're alive, what happens, who you appoint, and then ultimately you pass away and what needs to be done. And in law, anything, if an estate is worth over £5,000, you have to apply for probate. In fact, that's not necessarily the case. The banks enable you to access funds when there's more than £5,000 in an account, but the estate has to be limited, and so you may not need probate. But again, it's always worth taking advice when somebody dies, just to make sure whether you do need to apply for probate. Probate is the actual document that proves the will. If you don't have a will, then you apply the same sort of way through letters of administration. But obviously with no will, you're bound by the intestacy rules, which may not be favourable to you and your family. So when somebody dies, the bank accounts are frozen. Only the funeral and inheritance tax will be paid until you've got the power, so the grant of probate or letters of administration. And then once you've got those documents, you are able to access the funds, sell the property, and part pay the estate to the beneficiaries. Sometimes people lose the original will, and we can prove copy wills if you have enough evidence to show that the will hasn't been revoked. And if you don't want us to assist you in applying for probate, we can do various other things for you, such as searches, landmark searches, which are searches to find assets that may have been lost. We can do missing will searches. We can produce estate accounts, tax affairs, and inheritance tax reporting. Currently we can do deed of variations, but again, they may be they're being reviewed at the moment as to whether the government wants lawyers to be able to continue to do deed of variations. I think they're very important, but there is issues as to why people shouldn't. Why the government doesn't want us to be able to do that. There are other areas that you can think about as well. I mean, I've talked about deputy applications if there's no lasting powers of attorney. Asset protection trust. Kate Godber, who's one of my colleagues, did a webinar some time ago on trusts, and she went into detail about various trusts, so I won't go into that at all. I think you can listen to her webinar if you want to about trusts, which was very informative. And that's the end of my webinar. Thank you very much for listening. If you do have any questions, my details are on the slide, if you can see the slide. If not, by all means, if you go on our website, it's Emma Fuller, you can email me any questions. You can phone up the office and speak to any of the private client department who would be able to give you any further assistance. And that's it. Thank you very much.